good morning to the officials who've joined us online, and good morning to any members of the public who might be watching today. My name is Kayla Murray, and I'm the Standing Committee Chairperson for Finance, Economic Opportunities and Tourism. So the purpose of today's meeting is essentially to formulate our negotiating mandate on the Public Procurement Bill, and thereafter our final mandate on the Upstream Petroleum Development Bill. So before we proceed, I would just like to offer an opportunity to the members online to introduce themselves, followed by the officials.
Good morning, Chair. Andrikus van der Westhuizen, member of the committee.
Good morning, Chair. Khalil Brankesh, member of the committee. Good morning to all the colleagues.
Good morning, Chair. Good morning, members. Good morning, colleagues. My name is Mbulelo Isaac Sileku, member of the committee. Thank you very much.
Thank you very much, everyone. If I can now hand over to the officials, I see we are joined by a few from National Treasury in particular.
Good morning, Chair. My name is Willie Matebula from the Treasury. Thank you so much.
Good morning, Chairperson. MP van Skoor, also National Treasury.
Good morning, Chair. My name is Leander from the National Treasury as well. And good morning, honourable members and other people on the platform. Thanks.
Good morning, Chair, honourable members, colleagues. I'm Piwing Esihle Mashabane, also from the National Treasury.
Yeah, thank you very much. I would just like to check if there are any officials who perhaps aren't from National Treasury who would also like to introduce themselves.
Good morning, Chair. Nicholas Stars from Legal Services, Department of the Premier.
Thank you. I also see Ms. Kole, who is the legal advisor from WCPP.
Good morning, Chair. Mpokwele, a legal advisor to the committee. Thank you.
Thank you very much. All right. So with that, we have not received any apologies today. And I'd just like to briefly touch on the rules of engagement for today. So essentially, the program is that we will consider the National Treasury's responses to the submissions, deliberate and discuss in the negotiating mandate, draft the negotiating mandate, consider and adopt it, and then move on to upstream. But I would like members to note, and those joining the call to note, that throughout the duration of the call, it's requested that you keep yourselves muted and keep your video off unless called on to speak, and just ensuring that you're in the most audible environment that you can possibly be. Of course, looking after your internet connection so that we can have you on board for as long as possible. With that, I would like to hand over to the department, the National Treasury, to brief us on their responses to the submissions made on the Public Procurement Bill.
Thank you, Chair, and good morning once more, and also good morning to the honourable members of the committee. And thank you for this opportunity to at least interact with the committee on the Public Procurement Bill based on the comments that were received. Chair, I just want to flag. We made a short a presentation, but it's quite long slides, but we're not going to spend too much time on it. Just to check and the colleague of mine, Advocate MP van Skoor, will also be part of the presentation. I'm just going to present the first few slides, and then I will offer her an opportunity to continue. Now, firstly, Chair, I must apologize that due to the time constraints, we were only able to send the comment matrix very late yesterday, and I think we apologize for that. And of course, this presentation was sent somewhere towards the middle of the night. But of course, the comment matrix that we have contains submissions with responses submitted to SECOF on 14 March 2024. So you'll see that the presentation has got those responses. And then I don't think this is the right one. Sorry, Chair. Just quickly check this is the right. Apologies, this is not the right presentation that I have. Just quickly look for the correct one.
No problem. I can confirm we did receive a presentation and are in the process of circulating it to members. But if you need assistance with writing, please let us know.
Please, Chair, if that's possible.
Okay, Ms. Adams, if I could call on you to assist, please.
Apologies, Chair. Okay, I'm just opening it because I've just received it.
No, thank you very much for your help.
Thank you, Chair. That's the presentation slide 1, if you don't mind. Chair, if you can just go to slide 2, yes, and then slide 2. Yes, that's a correct one. So we're saying that, this presentation is just a summary of responses submitted to this committee on the 21st, which was yesterday. And of course, there is an annexure to this presentation, which contains the same responses made to SECOF on the 19th of March, which was this Tuesday, from 4 stakeholders, namely the African Procurement Law Unit, as you can see, Public Affairs Research Institution, the City of Cape Town, and the JSR. Now, the responses, of course, to comments on constitutional matters and other matters are the same as those presented to SECOF on 19 March, and they form part of this presentation. Can just move to the next slide. Okay. What we did, Chair, in the submissions that we received, especially written submissions, I'm sure that coupled with the oral submissions that were made during our visit in the province, we just picked up key concerns from the number of submissions that we want to at least indicate to the committee, and what our responses are to those key issues from submission. Firstly, Chair, there was a concern that the separate bill, which is this public procurement bill, could potentially detach procurement from the integral components of revenue, expenditure, assets, and liabilities that are governed by financial mechanisms and controls. So basically, the concern is don't separate procurement from the PFMA and MFMA. That's in a nutshell. That's what it means in a nutshell. Now, we say at least it should be noted that the PFMA and MFMA, on the one hand, and the bill on the other hand, are provided through recognizing the role of accounting officers and accounting authorities in making procurement decisions, and also proposing in the schedule to the bill amendments to the PFMA and MFMA. Basically, the accounting officers and authorities of procuring institutions will remain responsible for both procurement and other functions mentioned in the PFMA and the MFMA. So that's basically what this is. Then there was also another issue around the fact that the bill does not effectively meet the standards set by Section 217. One in reconciling the requirements for transparency, all those 5 elements of Section 217(1) of the Constitution. Now, our response here is that, of course, as you know, that we've always been saying that this bill is premised on sections 195, 217, and of course 216 of the Constitution. Now, if you look throughout the whole bill, you will see that there are various provisions in the bill that deal with these principles, the 5 principles that are mentioned in section 2171, so throughout the bill. And these provisions, of course, are referred to also in the preamble and the objects of the Act, which is clause 2. And then the bill read together with regulations will direct procuring institutions on how to give effect to these principles, talking about those 5 principles of transparency, competitiveness, equity, cost effectiveness, and etc. Chair. If you can just move to the next slide. Now, there was also a key issue around the dispute resolution process, which is proposed in the bill. And the stakeholders are of the view that this, dispute resolution mechanism in the form of the tribunal is administratively complex and impractical in the public procurement environment. And they even go further to say it obscures lines of accountability and seemingly, which is very, very important, appropriates judicial powers to the proposed tribunal. Now, our response here to was that the dispute resolution procedures are aimed, as we've always indicated in our presentations at various fora, that are aimed at saving costs, not only costs for the state, but also costs for businesses, including small businesses, Chair, who do not necessarily have huge pockets and deep pockets to litigate against state in cases where they are dissatisfied with the decisions of procuring institutions. And then, of course, also the issue around the turnaround time, because we know that the court processes themselves, by their very nature, take very long. And by that time, there's a huge impact on the service delivery. So the remedy, of course, are clearly set out in chapter 6 of the bill. And we also say that tribunals are provided for in other existing pieces of legislation, for instance, in the Financial Services Tribunal, which is in the Financial Sector Regulation Act of 2017, and also another tribunal in the SASSA Act of 2004. Now, it is not a proposed appropriation of the judicial powers, but a remedy to be used before seeking judicial review. So in other words, we've also made it compulsory for aggrieved suppliers, to exhaust this internal mechanism, and before approaching court for judicial review. That's the purpose. Then there was also another issue around the doctrine of functus officio, which dictates that administrative decisions made by delegated authorities are final and unalterable once rendered. Now, here, of course, Chair, I think, and members must know that the doctrine of functus officio is overridden by legislation. So in other words, where there is legislation, then that doctrine does not apply. And of course, as indicated, the purpose is to limit the need to go to court to rectify such decisions. The next slide. There was another issue, and I think in the later slides, we'll also, get onto this particular slide where the stakeholders were of the view that the bill either removes or curtails the powers of provincial government in respect of these functional areas, and that too is unconstitutional. I mean, there is a whole set of slides that are dealing with the constitutional matters, and this is one of them. Now, what we're saying here, Chair, of course, the bill is a national legislation, and does not in any way curtail the powers of any provincial government. And of course, the bill is premised on sections 195, 216, and 217 of the Constitution. Therefore, it cannot be said to be unconstitutional, and in no way curtails the powers, because here we're talking about procurement. So procuring institutions and provinces and so on, as indicated earlier on, accounting officers and authorities of various procuring institutions will still be responsible for taking procurement decisions. But those decisions, of course, must be within the rules of the game set out in this bill. There was another view that the BEE Act is applicable to preferential procurement, in that it regulates Black economic empowerment. This view, of course, is premised on the fact that there seems to be a element of this bill that seeks to discard the broad-based Black economic empowerment. That is it in a nutshell. Now, Chair, what we're saying here, the bill does not tamper with the BBBA provisions. I mean, the BBB Act will still, of course, apply going forward. These are two pieces of legislation, so there's no way that. But insofar as the proposed amendments that we've made, which of course are in the schedule to this bill, the BBB Act will remain intact, and all procuring institutions will continue to apply it. The next slide. There's this other view, Chair, around the fact, I mean, stakeholders saying, I think this comes from chapter 4, where they're saying subcontracting should not be made as a condition of the bid, but I'm sorry, yes, it should be made as a condition of contract. Now, what we're saying here, there is a clear distinction between clauses 19 and clause 24 of the bill. Well, it is accepted that there would be certain areas where subcontracting as a condition of contract is required. However, clause 19 intentionally provides for subcontracting as a condition of bid as a measure for preference, since the bidder would be required to state upfront that that bidder is willing to subcontract. And the requirement is linked directly to provisions of Section 217B. This is, of course, the protection or advancement of persons or categories of persons, previously disadvantaged by unfair discrimination. Now, should the bidder not be prepared to meet the condition as stated in the bid document, there's something missing there. So it means that bidder should be disqualified. That's a word that's missing there. It should be disqualified. Now, I must also add here, Chair, and say, if one were to leave subcontracting to the discretion of bidders to consider after award of a bid, there is a huge risk that suppliers would simply ignore subcontracting because it is not a condition of the bid. And therefore, in a way, dilute or even discard this lever. This is a very strategic lever, subcontracting for small businesses. And I know that people have always raised an issue of the construction mafia. We all know that the issues of that around construction mafia is a criminal element, and then those people that are hijacking projects in various provinces, in our view, should be reported to law enforcement agencies. So rather than taking subcontracting as some sort of a condition that would be considered as and when suppliers or bidders feel like to do so. I mean, that's what we say. So we remain with the view that subcontracting should continue to be a condition of the bid. You can go to the next slide, Chair, I think, yeah. Then there's also this issue around that the tribunal has the potential to paralyze procurement in the public sector. In the sense that there is no provision is made for the maximum period within which a ruling must be made. So in other words, the review process by the tribunal, people feel that if there is no time frame set to say this is the time frame, the tribunal must complete its review within this certain period. So what we are proposing here, we're proposing to include in clause 48 that the tribunal rules must provide for a time frame within which an order must be made, which may only be extended with the approval of the chairperson of the tribunal. So that's a proposal we make to clause 48 of the bill. There's also a concern that provinces and municipalities may lose their grant funding or even donor funding to that extent during the standstill period, because the bill provides a standstill period. In other words, while the tribunal processes are ongoing, there is a standstill. So in other words, no decisions to be taken, and stakeholders are concerned that this might, of course, impact on service delivery. There could be significant delays, may also result in the need for more costly solutions. Now, our response to this particular concern is that there are also far-reaching implications and risks in proceeding to conclude a contract which may later be set aside, whether set aside by the tribunal or set aside in a formal court. So that's why that provision is there to say, while a matter is referred to the tribunal for consideration, at least procuring institutions should not proceed, but they must wait for a decision of the tribunal to take place. However, Chair, we're saying in clause 55, there is a provision that should there be a need for emergency procurement procedures to be invoked in that instance, that particular emergency procurement should be implemented or invoked. We can go to the next one. Then there is this also issue around that PFMA Section 3 and the MFMA Section 2 have similar trumping provisions that may lead to stalemates between different legislative schemes operating in the context of public finance with no way of resolution. Now, the trumping clause in this bill, of course, is only limited to issues that relate to procurement and not in any other issue, either in the PFMA or the MFMA. So that's the position that we have here. Because the bill seeks to provide a single regulatory framework for public procurement, but for all other financial matters which are regulated in those two pieces of legislation, I mean, that process will continue as it is. The next slide. Chair, let me then invite my colleague, Advocate Van Schoor, to take the committee through some of the constitutional concerns raised, and then the responses thereto, and of course other issues which are not necessarily constitutional matters. Thank you so much, Chair, with your permission.
Absolutely, please go ahead.
Thank you again for the opportunity to present to the committee and to stakeholders present. Now, there's obviously quite a few comments that we received, not only to the Select Committee, to the NCOP, but also in various provinces and also in the case of Western Cape, which pertains to concerns about the alignment of Chapter 4 with the rest of the bill. And whether Chapter 4 is a framework envisaged in 217 of the 3 of the Constitution, and also requiring clarity on set-asides, pre-qualification and subcontracting. Now, I think it's important that this Chapter 4 shouldn't be read on its own. It must be considered in the context of the procurement system that's provided for in 2171 of the Constitution. And then specifically as regard the procurement system, it's linked to Chapter 4, which provides for a framework for this system to be prescribed by regulations. And then the requirement in terms of the proposal in the bill is that procuring institutions must implement their procurement systems and policies, taking into account the particular nuances of their sectors and industries. Now, a quite important adjustment for us in relation to dealing with the preparation of this bill and subsequent comments is the Agribusiness case with the Minister of Finance that dealt with the legality of the 2017 preferential procurement regulations that were made under the triple PFA. Now, what Judge Mslanhla said is, I think, quite important in an interpretation of Section 217, stating that the standalone reading of Section 217, which ignores Section 2171, is not only a disservice to statutory interpretation, but also ignores the founding values of the Constitution. Now, this confirms that national legislation providing for a framework to give effect to 2172 must take into account the founding values of the Constitution and the need to deliberately redress past discrimination practices and to provide for measures to make a meaningful difference to the lives of people who have suffered under the pre-April 94 dispensation. And more of this can be read in paragraph 60 of the judgment. Next slide, please. Now, further regarding preferential procurement, 2172 and 3 of the Constitution, it's clear that Parliament is entitled and also required to enact legislation laying down a framework for the implementation of a preferential procurement policy. Now, the question how tight or loose that framework is, that is how much discretion it affords to organs of state to develop their own policies, or if there's a national policy described, that is for Parliament to decide. Now, I refer you to a senior council opinion we obtained, and I apologize. I realized this morning that we haven't submitted to committee, but we did ask our parliamentary office to send it through to your committee to consider as well. So this is what the opinion said, that it's up to Parliament to decide how tight or loose this framework must be. And then another important point that's addressed in the opinion is if you read 2172 of the Constitution, he confirms that the reading of that provision is that it's discretionary for organs of state to implement such policies, but the opinion advised that Parliament may, through legislation, require that institutions must use procurement policies as envisaged. So it's in 2172, not 1 of the Constitution. Next slide, please. Now, on the question of pre-qualification that's provided for in clause 19 of the bill, and then subcontracting in clause 20 of the bill. So I'm going to check if I have to right now. Sorry, pre-qualification in clause 18 and subcontracting is in clause 19. Now, these two elements or provisions that are provided for in those clauses are included in a manner that align with the aims of 2172 and 3 of the Constitution, especially if you consider the majority judgment in the case that I mentioned earlier. The court said happily both the first judgment, that's the Supreme Court of Appeal judgment, and this particular judgment, indeed, the minister understood the imputed regulations to do what it's envisaged in 2172 of the Constitution. Now, the 2017 regulations that were the subject of this court judgment did provide for pre-qualification and subcontracting. But the court decided that the minister didn't have the authority in terms of legislation to prescribe this. Next slide, please. Now, then on the question of set-asides, which is dealt with in clause 17 of the bill, we submit that it's not correct that it's unconstitutional. If you consider 217 of the 2 of the Constitution, it provides for preference and allocation of contracts in 2172A, and then in 2172B for the protection and advancement of persons or category of persons previously disadvantaged by unfair discrimination. Now, the reason that set-asides were regarded in the agribusiness case as not being valid was that the founding legislation, the triple PFA, did not provide for set-asides per se, but for preferential procurement to only occur within the context of a preference point system in the context of 2172. Again, if more reading can be done with reference to paragraph 69 of the agribusiness case. Now, it's important to note that Chapter 4 of the bill provides for a menu of preferences to provide for meaningful redress of the imbalances of the past. Next slide, please. Now, continuing on, sorry, I think this is the same slide, if I'm not correct. Yes, sorry, I don't know if there was a duplication. And just apologize, I'm just checking my own documents. So shortly. Yes, it's a slide. Thank you very much. Now, preferential procurement. The Chapter 4, in our view, goes further than. The bill goes further than Chapter 4 in that it does not merely provide for preference point system. Sorry, our language is not entirely correct. I apologize, but for the preference point system, but other measures which will ensure meaningful empowerment of previously disadvantaged. So it seeks to address the fundamental constitutional provisions in 2172 and 3 of the Constitution, and it provides for regulations to be prepared with the necessary conditions, thresholds, parameters to ensure that these preference measures are implemented in a responsible manner. And this would these regulations we submit should look at provisions that address negotiations with bidders, which is envisaged, which include the negotiation of a fair market price to prevent government from paying exorbitant prices for contracts awarded. Then I think the important point that we want to make is that all the subsections of 217 are designed to coexist within a procurement system envisaged in 2171. And the Constitutional Court did confirm that the 5 principles in 2171 do not become a nullity when you apply preferential procurement in terms of 2172. And the tenders must be evaluated in a manner that gives effects to 2171. Next slide, please. Now, my colleague already dealt with this aspect about the 5 principles in 217, so I'm not going to repeat what you already dealt with. So, next slide, please. Now, as to the scope of the bill, one of the submissions, or there may be more than one, that made an argument that the bill goes beyond what's provided in 2173 of the Constitution. so that it not only deals with a framework for provincial procurement. I think the important point to make is that national legislation like the PFMA and the MFMA currently are within Parliament's legislative authority. And then 21761 of the Constitution that require national legislation to prescribe measures to ensure transparency and expenditure control in each sphere of government by introducing, among others, uniform norms and standards. Now, in our view, the uniform norms and standards includes the regulation of public procurement. Next slide, please. Now, on the issues of corporate governance, there was a view held that the bill infringes on the constitutional status and powers of provincial and local government. I did mention now the provisions of 2171 and 2, and also in 2172 specifically that National Treasury is required to enforce compliance with these uniform norms and standards. And then I think that we've repeatedly said that Chapter 4 is based on 2173 of the Constitution, and which provides that national legislation must prescribe a framework for the policies on preference. And 2172 applies to organs of state and a national, provincial, and local government. So it's permissible for that the bill extends, and even 2173 is written in a way that's compulsory for Parliament to make such a law to set a framework. Now, the regulation of provincial and local government in the bill is comparable to the PFMA and the MFMA, as well as the triple PFA provisions. Now, MFMA currently contains a chapter on supply chain management, and there's also a separate set of SCM regulations made by the Minister of Finance. Then the Minister of Finance may also make regulations under the PFMA, and these are applicable to national institutions and also provincial institutions not mentioned here, which are contained in the 2005 Treasury regulations. The triple PFA, that's the current legislation dealing with provincial procurement, also applies to provincial and municipal institutions. Next slide, please. Now, further regarding corporate governance, now the bill proposes that procurement, including preferential procurement, be regulated in a single statute. In our view, this is not precluded by the Constitution. As to the legislative and executive authority of municipalities in Section 151 and 156 of the Constitution, Clause 8 of the bill provides that the procuring institution, that would include provincial institutions as well as municipalities or municipal entities, that they must implement a procurement system which includes a procurement policy in terms of the system prescribed under Clause 25. So therefore, municipalities' authority in this regard is not impacted. They must, the requirement is that the system must be implemented in terms of the framework set through regulations. But the details thereof is obviously up to the municipality to do so. Then there was also concerns raised about not consultation with Minister of Cocktail on draft regulations. Now, there is a requirement in the bill that relevant ministers must be consulted on regulations that affect their portfolio in Clause 64.2. I think you will also note that we later on made a proposal that we specifically include the provision that organised local government, which is now currently represent or SALGA is the institution, recognise that they must also be consulted on regulations that affect municipalities. Next slide, please. Now, to address the concerns about the application of the measures to local government, we made the following proposed amendments already to the Select Committee of Finance in the NCOP. Now, the first proposal is that the authority for the Procurement Office and the Provincial Treasuries to issue instructions that apply to municipal institutions be replaced with a circular or perhaps a guideline that the municipality would have a choice whether to adopt or not, which is similar to the approach in the MFMA. And it's also proposed that the enforcement function for provincial treasuries regarding municipal institutions be omitted, because if you consider 21762, that enforcement role vests in National Treasury. And then, as I indicated earlier, the requirement that organised local government be consulted on draft regulations affecting local government. Next slide, please. Now, stepping off to maybe the clear issues on constitutional issues, there's concerns raised about the independence of the Public Procurement Office and that it should not be part of the National Treasury. Now, Section 2162 of the Constitution mentioned earlier clearly provides that National Treasury is tasked with the enforcement of compliance with uniform norms and standards, which I indicated earlier in our view includes procurement prescripts. Therefore, in our view, placing the PPO in Treasury accords with that provision of the Constitution. And then I think what does assist to have some separation from the other functions of National Treasury is that the bill proposes original functions for the PPO. And I think another important issue or aspect to consider is that the role of the PPO and also provincial treasuries pertains to when government procures services. It's not dealing with when the private sector procures. Therefore, in our view, there's no need for the Public Procurement Office to be independent since it performs a function for government, and as indicated also in respect of the role of provincial treasuries proposed in the bill. Next slide, please. Now, as to the functions of procurement, the Procurement Office and provincial treasuries, as well as procuring institutions, the views expressed by some commentators that it's not clear what their respective roles are. In our view, the roles of these three different institutions or categories are clearly set out in clauses 5 to 8 of the bill. Provincial treasuries functions are the same as the Public Procurement Office, but obviously only within the province. And then some of the functions of the Procurement Office in National Treasury is part of its role to set uniform norms and standards through instructions. But there's also, as you know, there's a provision for provincial treasuries to determine instructions within a province. In our view, the functions of the PPO are comparable to the current National Treasury functions under the PFMA and the MFMA. Regarding the issuance of binding instructions, the bill makes it clear that there's specific cases where it's provided that instructions must be issued, and the more general power is for the effective implementation of the Act. In the case of provincial treasuries, there's the general power to issue instructions for the province for the effective implementation of the Act. Next slide, please. Then on decision making on procurement, and my colleague already touched on this, I'll just quickly go through this particular slide. Now, firstly, our view is that there is no centralization of procurement. The bill does not change the current position on decision making on procurement. And then it's important to note that the Public Procurement Office will not be the chief buyer for government. There's no such proposal in the bill. Then in clause 7, it clearly indicates that decision-making on procurement vests in the accounting officer for those different institutions mentioned, and then what the term used for public entities in the PFMA accounting offices. So they all make decisions on procurement, but obviously must implement their procurement system and the policy in accordance with the bill. And also the framework determined by regulations. Then also important, the alignment between the PFMA and the MFMA and the bill are provided for recognizing these roles of accounting officers and authorities. And then you will note there's also there's proposed amendments to the PFMA and the MFMA in the schedule to the bill to essentially to remove provisions pertaining to procurement. Next slide, please. Now, My colleague also touched on this earlier, but just briefly, some commentators say we're not doing enough for integrity, transparency, accountability, and anti-corruption measures. Now, firstly, those provisions that he did indicate that the bill is premised on. Then, and I think important issue to note is that the fight against corruption and introducing anti-corruption measures needs a collaboration with other government institutions as well as law enforcement agencies. And the bill can't be the only instrument to combat corruption. And as to the proposed anti-corruption agency by the Zondo Commission, that is best placed with the departments in the justice cluster. Next slide, please. Then, just to indicate the various provisions that deals with especially integrity and accountability and anti-corruption measures, the bill provides for codes of conduct for everyone involved in procurement, from officials, bidders, and so on. And also it provides for a provision on undue influence in a procurement process, and it requires role players to declare interest. Then there's also a provision that excludes certain persons from even participating in a bidding process, for instance, like public office bearers. Then there's also provision that for the debarment of bidders and suppliers where they've committed to certain transgressions. Then an important provision for officials that receive directions for people in position of power that are contrary to provisions of the Act and how they would be protected. Then there's also provisions dealing with criminal offences where false information is submitted during a bid, and also offences relating to corruption and other fraudulent acts. Thank you. Next slide, sorry. Then just lastly, to highlight many of the transparency provisions which obviously assist with fighting corruption. Firstly, it's mentioned in the objects clause, the debarment register, one can see who has been debarred. Then in clause 30, there's provisions for access to procurement information, services, and also open data. 32 deals with access to procurement processes, and then 33 with disclosure of information. And then obviously the process on transparency in making regulations and instructions in 64 and 65 also assists with improved transparency. Next slide, please. Just briefly on whistleblowing, a number of commentators said that we should incentivize whistleblowing in this bill and also provide for better protection. Now, Treasury's position is that this should be done through amendments to the Protected Disclosures Act, which is administered by the Department of Justice. Now, there is a detailed discussion papers was published by the Minister of Justice in 2023 for comment. The comment period has since closed, so they're working on amendments to the bill. And there are different views about whether whistleblowing should be incentivized or not. Now, some of the comments that we received during hearings in the provinces is that that this would create an unwelcome market for criminal conduct where unscrupulous people would plant information implicating persons and then fabricate proof and then later attempt to claim payment. So the argument made or the position taken was that instead of paying whistleblowers, there should be improved protection of whistleblowers. And I think the important comment, and as people would know about the recent incident where a person was killed due to what we understand because of whistleblowing, is that how much money can save a life. Next slide, please. Then just on the interaction of the bill with other acts. Now, obviously, there's a number of acts that are relevant in the implementation of this bill, POPIA, PADJA, the Public Service Act and the CIBD Act, Companies Act, as well as the BBBE Act. Now, the provisions of some of the acts in the schedule to the bill are proposed to be amended to be aligned with the bill. And these will be scrutinized again, that we make sure that the required alignment are obtained, is obtained, sorry. And then, because obviously it's not ideal that one rely on a trumping clause, which is in clause 3.4 of the bill. And I think my colleague did mention the trumping clauses in the MFA and the PFMA. Now, the trumping clause, obviously, this will be a later bill, so it will trump provisions passed prior to once it's enacted, in case there's conflict. But it's not ideal that that should be done. We should make the required amendments to other legislation. So therefore, we would again scrutinize. We did receive comments from some stakeholders that we are considering for possible further amendments to other legislation in the schedule. Next slide, please. The issues of the tribunal, my colleague have dealt with, I think, the first point on the tribunal. The only two other aspects I want to raise is the last 2 points, is that one of the concerns was the capacity of the tribunal to deal with disputes or reviews across the country. Now, currently the Act, the bill does provide for a panel to be constituted for each application. But what we propose that clause 48 be amended so that it specifically deals all through rules of the tribunal to operate on a provincial level to deal with applications in each province. So that's a proposed amendment that we are making to the Standing Committee of Finance in NCOP. Then there was concerns raised about the costing, which is we did indicate cost implications in the CIAS, but it was not indicated in the memo to the bill, which was an oversight. But the tribunal cost will be carried obviously through appropriations from the National Revenue Fund by Parliament in an appropriation legislation. And only once a proper cost estimate has been done and the tribunal is ready to commence its work, then the provisions relating to the tribunal will be proposed to be brought into operation. Next slide, please. Then another concern was raised that do we regulate too much or leave too much to be regulated by regulations? I think the important provision to consider is Section 239 of the Constitution, which defines the term national legislation when used in a constitution to include subordinate legislation. And one needs to link that to 2161 and 2173 of the Constitution. So where there's references to national legislation, it would include subordinate legislation. Now, the bill aims to set a framework for procurement with specificity to be provided in ministerial regulations and PBO instructions, which we submit is limited in nature, and then opposite there will be, which is not mentioned here, provincial instructions. And then, as indicated earlier, the procurement systems and policies of institutions must be determined in the framework of the bill and the requirements of the regulations. Now, the primary reason to allow for different regulations to be made for different regulations to be made for different categories of procurement. For example, for infrastructure and triple Ps, and then maybe specific regulations on goods and services. And then also be justified to provide for different categories of institutions, and then also for the requirement for flexibility to adapt to new developments in procurement. And the obvious reason for having regulations or provisions in regulations is that could be changed without amending the primary legislation. But despite these considerations, I think it's important that the process to develop regulations is more rigorous. The draft regulations, according to the clause 64, must be published with the statement of need, the intended operation, and also it must be published. Must be published with the statement and the operation. So it's the expected outcome. Then there's also a requirement, as mentioned earlier, that the relevant ministers must be consulted, and then there's a requirement that the regulations must be subjected to parliamentary scrutiny before they may be issued. And then also what I mentioned earlier, that we propose that we especially require consultation with organized local government. Next slide, please. Then concerning the financial implication of the bill, the elements of the procurement system, which you'll see in clause 25, in our view, are existing elements in institutions or functions which may only have to be made part of the procurement system of institutions. Linked to this, expanding the scope of the procurement functions in institutions, and most of these are not new functions, but it's now especially maybe in the case of national provincial, elevated to primary legislation. And in our view, the shifting of functions within institutions should result in minimal cost. And then also there's some commentators said that the enforcement function for provincial treasuries is not new. Now there's already an enforcement function for provincial departments. So I think it's for provincial treasuries in respect to provincial departments in section 18.2b of the PFMA. And then, as I indicated earlier, we propose that this enforcement role for provincial treasuries in respect to municipalities be removed. Now, as the investigations about allegations, which is provided for in clause 27, and the subsequent steps that must be taken, again, those are functions that are already required in terms of the triple PFMA and the MFMA, and the prescript issued under those two acts. Next slide, please. Now, the investigative powers of the Public Procurement Office. Now, clause 56 make it clear that the purpose of these powers is for compliance, and it's not to investigate alleged criminal conduct. Then, just to mention some institutions that currently have such powers, which are regulatory or supervisory bodies. The Financial Sector Regulation Act provides for the Prudential Authority and the Financial Sector Conduct Authority to have such powers, and then also the FIC in terms of the Financial Intelligence Center Act. And generally, you'll see such provisions for regulators like the Property Petitioners Council Board under the Property Petitioners Act. Then there was also concern raised about the authority to request warrants from in terms of clause 58 of the bill. Now, it could only be sought by a person authorized by the PPO, so it's not can't be done by other procuring institutions. Apologies, Chair, I recall a comment from, I think, your legal advisor to the committee about if criminal conduct is detected during such an investigation, which we now say it's only for compliance and not to investigate criminal conduct. I do think it's something that we need to consider to put in a provision as to what if they detect, criminal conduct, specifically say it must be referred to the law enforcement agencies. It's something that we haven't yet proposed to the select committee at this stage, but we will consider it for inclusion in our next presentation to the committee. Next slide, please. Sorry, that was the end. Thank you very much.
Apologies. Thank you very much. Right. So with that, I would now like to give members and possibly the officials, including my legal advisor, an opportunity to ask any questions to the department. If members can please raise their hands, or officials. Member van der Westhuizen.
Yes, thank you, Chair. Just the first question. In terms of the tribunal, what would the membership of the tribunal be? My reading of the bill is that the minimum number of members might be 3, but that there's no maximum to the number of members that the minister may appoint. Is that the minister may appoint as many members as the minister sees fit, which theoretically may mean that the tribunal could eventually consist of 100 members if the minister sees fit. Is there any limit in the bill that would ensure that the tribunal therefore is effective, that the tribunal is not too costly, and that the tribunal would be able to deal swiftly and not cause the delays that some people have expressed concerns about? Thank you.
Thank you very much. Before I hand over, I'll just quickly hand over to Member Nkondlo.
Thank you, Chair. Can you hear me?
Yes, Member.
Oh, thank you, Chair. I just wanted to confirm if I understood the colleagues properly, particularly on the relationship of this framework to the other pieces of legislation, particularly on the different categories of procurement, be it construction and related, whether such will be resolved through the regulations. And is there any indication from the department at this point of how soon will those regulations be developed? And in the period whilst they are not developed, what becomes the validity of this bill as and when it gets to be approved or not? And I'm raising this in context to the notion of debarments. For example, one issue that I know has been raised, I think, in the infrastructure procurement space, particularly around your construction-related procurement, is the fact that on one hand, you have a situation where some of your high-end CIDP gradings, especially the big construction companies, who are able, by virtue of their muscle, financially and otherwise, be able to take up projects. It could be national or whatever, big projects. There is a reality that government is still dealing with, where some of them would actually run out of cash because the monies are actually tied to different projects. It could be projects in South Africa and otherwise. Thus, such instance would then affect the timing, timeous delivery of infrastructure projects. I know, for example, here in the previous Department of Public Works, now infrastructure, we had such cases reported by the department in their books. And the question when we ask, are there any measures, to punish such bidders? Because the reality, such has got direct service delivery implications for government, because those are public infrastructure projects. It could be schools, whatever, and at the time it was said there is a gap in legislation for such. So I'm raising this to also bring this to the fore around such measures that needs to be undertaken. My second one, Chair, is that I'm interested to understand that the issues raised, especially from the concerns about particularly the issue of trampling on municipalities and provincial powers, isn't the Constitution of South Africa to date, from its inception, have adopted a fiscal decentralization approach, both in terms of its budget allocation and spending, which actually, whilst allowing the three different spheres independent and very clear, distinct powers, but also an intergovernmental or an alignment of these three spheres. Why I'm asking that? I'm asking in relation to what is being raised in the comments about the issue of provinces and municipalities, because my understanding of a public procurement embedded in the PFMA is actually aligned to that constitutional provision and spirit. And therefore, any question that seeks to create a separation of these three spheres into some type, of standalone is not in sync with the Constitution, and how over time to date, unless somebody is asking for a constitutional amendment, the governance structure of South Africa in terms of its policy approach in terms of budget allocation and how a budget are supposedly to be spent is actually within that fiscal decentralization, which allows the three different spheres to still have their individual powers, but also take note of how these three must actually work together. So for me, any input or submission that seeks to actually create a void, of these three spheres is actually, in a way, contesting the constitutional spirit of the Constitution that we have in the country. So I'm interested to understand this, because my concern about this kind of question is really taking us out of what it claims constitutionality, but actually, in my view, it is actually unconstitutional to expect that the lawmaking in South Africa must actually create these three distinct spheres as separate, because they are not in as far as the Constitution, unless somebody actually calls for a constitutional amendment. So I just wanted to understand and get that particular clarity from the colleagues, particularly on these constitutional concerns. Thank you.
Thank you, Member Nkondlo. I'm just standing in for the chair. Good morning, colleagues. And I'll give over to the department to answer to the questions. Thank you.
Thank you, Chair. Let me allow my colleague advocate Van Schoor to respond to the membership of the tribunal, as well as the very last question around cooperative governance. And then I'm going to be taking on the issues raised on construction, the department, and so on. Thank you very much.
Thank you. Regarding the questions about the question about the tribunal, what is required in terms of the appointment in clause? Sorry, I'm just finding the right clause. Is that the minister, as the member indicated, that he must firstly appoint a retired judge that will be the chair, and then it says sufficient number of persons with 10 years experience in the law, and then sufficient number of persons with 10 years experience in procurement. Now, the reason why we use the sufficient numbers in both instances, because it will depend on how many applications are received. So as and when applications are made, it may be required of the minister to appoint additional members. But the chairperson is the one that will put together the panel for each application, which is now dealt with in clause 47 of the bill, which will again, there will be one member that's the chair of the panel, and then of these two different categories, either a lawyer, well, not either a lawyer and a procurement specialist must be on the panel. And there could be additional members. So it's very difficult to set a limit because it's going to depend on, how many applications are received. But and then as the proposal is that we will specifically, if the SECOF committee accepts that proposal, that the tribunal rules will determine specifically that the panels must have a provincial presence. So I don't think, I think it will be very unfortunate if the minister appoint too many people, and they will only be paid if they hear application. So it's not they're going to receive any remuneration by the mere fact that they're appointed. So I think that's the important consideration, that in that way there will not be too much cost involved that's not justified. They will only when they serve as members hearing an application, they will be paid. I hope that clarifies the question. Thank you. Then on the last, on the constitutional issues raised by the member, I think I just want to go back to what we said about 2161 and 2 of the Constitution, where it states that national legislation must lay down uniform norms and standards regarding expenditure control and transparency. And then secondly, in 2162, it says that it must, those uniform norms and standards must be enforced by National Treasury. And then as put out in the presentation, is that those uniform norms and standards includes procurement rules. Then if you go to 2173, that requires a framework to be determined in terms of which organs of state must implement their preference procurement policies. That's again national legislation that must do so. And what we are arguing is that, the bill will lay down a framework for general procurement requirements together with regulations, and then similarly also Chapter 4 lays down the framework together with regulations for preferential procurement. But the decision making by any institution, whether in national, provincial or local government, on whether to procure something and the process to be followed, that is well, I shouldn't say the process to be followed, but a decision to who to appoint eventually, that's in the hands of that institution. It will not be determined centrally. And this is no different from what's currently provided for under the PFMA and the MFMA in respect of procurement and the relevant regulations and instructions issued under that legislation. But that position is not changed, and also because we can't, because that is what constitutionally a province and a municipality is entitled to do. So yeah, I hope I explain that adequately for the member. Thank you.
Thank you very much.
Chair, I just wanted to at least respond to the other question related to the relationship between this act and the other piece of legislation. I mean, there is a schedule to the bill where there are proposals to either amend certain parts of a certain piece of legislation as well as even repeal some. So there is that relationship. The second part is that the bill will be implemented in a phased approach. So it's the second part. Now, let me come to this very critical issue that the member has raised around the fact that in the construction environment, the built environment, you only have a few specific service providers or contractors that undertake big projects, and at some point in time, they run out of funds. And therefore, that has got an impact, direct impact on the delivery of infrastructure. I think this is a very serious one. In our interaction, not only here during SCOF and also during our visits, this issue came out. Some people were even saying, no, why don't you scrap the CITP Act in its entirety? And then our view has always been, look, that particular proposal is left to Parliament to decide. But at least as far as we are concerned, we are making certain proposals for the amendment of the CITP Act so that it is aligned to this Act. Now, there is one fundamental issue which is a reality in this country, which relates to the grading system of the CITP. You would know that if you're looking at the bulk of where your contractors in the built environment sit, they are between grade 1 up to grade 6, right? And I think there's also a limit in terms of the number of, in terms of the value of the projects that those contractors can do. So then if you go to grade 7, and also grade 7 has got also a limit in terms of the threshold, the value of the projects that they undertake. And there aren't many of these contractors, by the way, in that particular range between grade 7 and grade 9. But then you go to grade 8 and grade 9, very few companies in that grade, in that band. And these are the real causes of why those big companies, which of course have got an unlimited value in terms of the projects that they can take. So they end up taking more than what they can chew, not only internationally, because I know they also bid for projects internationally, but here in the country as well. And some commentators during the Free State visits were saying, these companies know exactly that if you've got a contract value of, which is unlimited, a billion and so on, there are only few of those companies that can undertake those projects. And in fact, the comment was, they know that they don't even need to bid; they will get those projects in any way sitting home, and that's the problem that we're having. So the one thing that we need to deal with insofar as the grading system, insofar as the CITP Act, is that grading system. Okay, so that you've got a larger pool of contractors in the high end of the projects, the high value end of the projects. Right now, you've got few. That's why they are able to simply take a lot of projects and they can't, of course, perform on those projects. They run out of cash and so on and so forth. But now, lastly, I must say, in the current regulatory regime, the current, there is a provision to act in terms of non-performance. So there is no gap there. So there's a provision to say, if these contractors undertake a lot of projects in the country and they are unable to perform and deliver on those projects, there's a provision to act against them in the current regime. But also in this bill, in clause 15C, 15.3C, 15.3C of this bill, it does make provision that at least a procuring institution or a government department and so on can take, of course, an action against non-performing contractors on contractual obligations, and not necessarily due to circumstances beyond their control. But if something is within their control and they've submitted a bid, they've been awarded a contract and they don't perform on that contract, surely the bill does have that provision. But equally, the current regime, regulatory framework, does make provision for action to be taken. And I think also beyond just the provisions in the regulatory framework, but when procuring institutions or organs of state and also departments are issuing tenders, I think this could also be a contractual matter. It should be in the contract itself to say, if a supplier or contractor fails to perform on a project, then the organ of state has got the right to cancel that contract and take action against that particular supplier who is non-performing. So I just wanted to address that particular question, Chair. Thank you very much. Back to you.
Thank you very much, members. Are there any additional questions? I see Member van der Westhuizen.
Yes, thank you, Chair. Quite frankly, I have not heard that there's any limit, and it seems to me it would be absolutely up to the Minister to decide how big the tribunal will be, as well as when it seems to be like subcommittees or sub-tribunals meet, and it's a concern for me. Chair, but my biggest concern actually has to do with the use of the word target. If I look on the internet for various definitions of targets, it's an object to be effected or achieved by an action or development. Or there's also, a definition which says, a target is something that you aim at, in the case of a physical target, etc. But now in our legislation, we have now started to have what we call prescribed targets. You can no longer aim to achieve something. We have now prescribed, what you must achieve. And I think it's an abuse actually of the term target. And I find it a real pity that there is no definition for the word target in the list of definitions to this legislation as well. And language says that the minister may prescribe targets that, and I'm referring here to 72A, the minister must prescribe targets for set aside, and the minister must every 2 years, prescribe any new target for set aside, and so on. Prescribing and targets is not, in my book, really compatible with one another. I know it has become the norm in some legislation here in South Africa, but I think it's an abuse of what the original meaning of target is, and I seriously object to that. Then we must say it's not a target; it's a threshold, or we must name it. I almost want to say correctly what is actually intended by that. But a target is something that you strive towards, and in this case, we even speak in some cases of minimum targets and so on, and that is not, I think, correct. And I would love to hear what is the legal advisor's definition of a target, and how do they reconcile that with what dictionaries, how they define the term target. The second one is also a procuring institution must set aside. Then it says there with a prescribed threshold and conditions. And as I've said, I think the word threshold is more appropriate than the word targets. And I would love to hear the comments from the legal advisors. Thank you.
Thank you very much. I think, given the request that the legal advisor come in, Member Nkundla, if you don't mind, I'll let the department respond first, then bring in the legal advisor, and then I'll come to your question. Is that in order? Okay, we'll proceed in that order. If the department would like to comment, Member Nkundla, so you've unmuted yourself.
No, I was saying it's okay, Chair.
Okay, thank you very much. Okay, I'll hand over to the department and then to the legal advisor.
Chair, let me just quickly try to explain. I'm gonna try and be short as possible. Look, what clause 17 says that the context in which this word target is used here, I'm sure the legal advisor will also come in, is that the target simply is what one aims to achieve. I think the honorable member is correct. It's what one seeks to achieve at the end of the day. That's what that target means. So in other words, when the set aside provision in this bill has been exhausted, and I'm sure my colleagues will also come in here, and then in the view of the minister that those targets have been met, whether it could be in terms of numbers or in terms of value of the contracts that would have been set aside for the specific categories as mentioned in clause 17.3, then it means that's that target. I can't explain it in any other way, but I hear what the member is saying. I just wanted to bring that perspective, and I'm sure my colleague can also come in here and explain what that means. Then when you're talking about thresholds, the thresholds in this context is much more related to value. So if I mean, this is also linked to clause 25, clause 25 of this bill, where it also indicates that the minister, of course, may set certain thresholds for specific categories of procurements. If you look at 25.2, it says the minister may determine by noticing the Gazette procurement thresholds and different thresholds for different categories of procuring institutions. This thresholds is linked to value, whereas a target here would be, in my view, based to relate to a particular number that this provision seeks to achieve. But I'm sure my colleagues will add to that as well, Chair. Thank you.
Thank you very much. I just want to check if your colleagues want to come in before we call Ms. Kwale in. Advocate Kwale.
Chair, I'm inclined to agree with the member, that when you look at the word prescribed target and a threshold, my view is that the word threshold would be more appropriate, because when you prescribing a threshold, it's a point or a value that something is whether or not something is achieved. But if it's a target, the difficulty is that if, let's say, somebody does not reach that target, how would it be, how would that be taken, the performance would be taken into account? Like, for instance, if the minister was to prescribe a target, shouldn't we rather prescribe it as a threshold? I hope that it properly articulates. And Chair, I also wanted now, and I'm not sure if the time is appropriate or not, I wanted to raise or ask a question around the regulations, because as a legislature and parliament, there lies the plenary lawmaking powers. And so the minister, when they make a regulation. It is a delegated law. It's a delegated power. So my concern mainly is, and it really is not addressed thoroughly, is that recognition between the lawmaking powers of Parliament and the legislatures and the delegated powers to the minister to implement the act. So that's all from my side, Chair.
Thank you very much, Advocate Kwale. You are absolutely within your rights to ask the question. I believe that helps to serve us better as a committee, because of course you have an insight that we don't have. You speak legalese and we don't. Let me just bring in Member Nkondlo, and then we'll hand over to Ms. Peterson and to PT to respond.
Thank you, Chair. I think maybe just contributing to the point being discussed. One was just looking at the socio-economic impact assessment that the department provided us. And I think on page 27, it actually tried to provide, if I think I'm having the page correct, it tries to provide some explanation about targets. Actually, under 2.9.1.3, it says, provide a comprehensive logical framework aligned to the policy. And then I think bullet number 5 speaks about the targets, and in brackets it says a specified objective that indicates the number, timing, and location of that which is to be realized. And considering that even within National Treasury, there is a logical framework that is used by departments across that when speaking about targets would always, and I think it's something that the member and members would know, we always deal with, and we're referred to also consider the annual planning of departments, that targets are not things that are just, thought of by anybody from the sky. Targets will always be set against benchmark a performance, which is previous performance based on resources that have been provided, and how the outputs of those resources would have actually realized a particular performance of that particular target. So I think it's something because it's not something that is new. But secondly, I would perhaps I am not sure whether it does exist. That one of the ways that is always easier, even in legislation, is to have a set of definitions so that in context to this procurement framework, I think the word target versus the word threshold and where it is applicable, such gets to be clarified. I think for me that would be also something that we should just consider, maybe as part of our recommendations, as part of the mandate. But second to this, Chair, I was trying to sort of also look into the socio-economic impact, because I think once again, if we stick to this conversation about target, it's always important to go back on two things. One, what is the problem statement? What is it that this procurement framework is seeking to correct? And I think that which is in the problem statement is always what needs to be read in context, because this legislation is not just a legislation, in abstract. It's a legislation that seeks to respond to a particular reality and peculiarity, which is actually distinct in the South African economy and its structural problems. So I would think, even in arguing the nature of target as a term, in simple or in literal form, such can always be alluded to in context to the peculiarity on which the context of the South African economy and its structural defects that this particular framework is seeking to achieve. And with that, actually, I would have wanted to understand whether any benchmark studies on how public procurement, not only in South Africa, in other both developing and developed economies has been developed or has been done by National Treasury, so that you seek to understand how countries are able to actually use public procurement, to respond to their own domestic realities and domestic interest. Is there any of such a study or insight that would have actually also assisted over and above, I think, the cases that have been explained very well, in terms of some of the challenges that would have dictated, the problem statement that we are dealing with. I just wanted to just understand that aspect of benchmark studies around public procurement, and its use in different countries to respond to, yes, general procurement across, particularly public procurement, but also in context to the domestic realities that a country or a state would want to utilize as such, in them, purchasing goods and services to try and respond to their own policy or country imperatives. Thank you very much.
Thank you very much. With that, I'll hand over to Ms. Peterson, and then I'll hand over to the National Treasury in general. Thank you.
Thank you, Chair. Yes, so I'm Leander, also from National Treasury. I think after the last member spoke, I wanted to actually lower my hand because I think she covered the issue of targets very well. But I think just so that's where I'm coming from the perspective of the targets. Just to say, indeed, so firstly, maybe where a word is not prescribed in the Act, it takes on its ordinary meaning. And a target is indeed something that is aimed at being achieved. So the members are correct. It's an aspirational objective. And the fact that it is prescribed does not necessarily exclude it from being a target. So it is that will be prescribed by the Minister in regulation, is that target, that aim, that aspirational objective that we are seeking, or that procuring institutions must then seek to achieve. But it should also be borne in mind that when that target is being considered for being set and for being prescribed, the bill makes provision that the minister must consult with the relevant minister, that is, whose portfolio those categories of persons for whom the target must be set falls under. So if, for example, the minister is setting targets for set-asides for women, then the minister that is responsible for women, youth, persons with disabilities must then be consulted before that target is set. And when something is prescribed, it means, as we said, prescribed by regulation. And you will notice that the process to develop regulations is a lot more rigorous than it has been in the past. So it will, firstly, there's that requirement to consult with the relevant ministers. Then there's the statement that will need to be compiled, setting out what that regulation seeks to achieve and what its impact will be. And then there's the public comment process, and then there's the parliamentary scrutiny that must take place, which is something that hasn't been there before when we set regulations on preferential procurement. So I think these are important considerations. And even as we had referred to the judgment in the matter between the Minister of Finance and Saka Liche, Agribusiness at the time. I think it's important, as the member was talking about the context, even in South Africa. South Africa is one of the countries, one of the fewer countries that has a procurement provision in the Constitution. And so one of the judges in that constitutional court case said that it must be emphasized that the scheme of Section 217 of the Constitution is that the section authorizes the state to, in certain circumstances, exclude from the award of contracts persons who did not suffer under discrimination under apartheid in favor of those who were discriminated against. So this exclusion constitutes an effective tool in the hands of the state to redress the injustices of the past regime and to heal the hurt and suffering visited by that order on the Black majority in this country. So I'm just quoting, Chair and members, what one of the Constitutional Court judges had said in relation to 2172 of the Constitution. So I think that's why the national legislation that is being prescribed under 2173 then incorporates such provisions that are aiming to look at 2172A and 2172B. And also to note that the Constitution defines national legislation as inclusive of the regulations. So I just wanted to, so that is why more detail will be provided for in the regulations with regards to the targets and with regards even to the concept of thresholds and conditions. Thank you, Chair.
Thank you very much. I just want to check if there are any further comments from NT.
Yeah, Chair, let me just quickly answer this one also in short, the very last by the member around whether Treasury has done a benchmark studies and so on. Yes, currently there is a process underway within the National Treasury called MAPS. This is an assessment of the procurement systems, methodologies, a methodology to assess procurement systems. That's what MAPS stands for. And this is driven by the OECD and through various countries and of course with the support of the World Bank. So it's a process that is underway as we speak right now, just to benchmark our own systems and systems of other countries as well. Thank you very much, Chair.
Thank you very much. I see Ms. Van Schuur.
Yes, so I just want to briefly respond to your legal advisor's issue about, well, basically what the Constitution allows Parliament to do, enables Parliament to do. Because obviously this is now proposed national legislation that we ask Parliament to pass. And then there's provision for, in the legislation, for delegation by Parliament of its legislative authority, which is now my colleague again mentioned that national legislation includes subordinate legislation. And the test is, do we, or does the bill adequately circumscribe the powers that the Parliament is proposed to be delegated? And firstly, it would be the regulation power, which is mainly in section 6, clause 64. And then there's the authority for national, for the PBO, the procurement office, and then so all provincial treasury to issue instructions. Now we submitted it's, we think it's much more clearly indicated than if you compare it currently with the PFMA as to what could be in regulations and what could be in instructions. It's separated now. Well, if you look at the PFMA, it's currently, we have a choice. You can either issue regulations or instructions, and instructions are not published in the Gazette. So you can argue it's not subordinate legislation. And then also, I think the test for lawyers is that, do we give too much scope to the minister to issue regulations or not? And we say, in our view, not. And that the flexibility the reasons for the flexibility, we explained why. And given the process that's followed in developing the regulations and also subsequently parliamentary scrutiny, we do think it meets the requirements of the Constitution. Thank you.
Thank you very much. Members, are there any additional questions? Final questions? I see none. With that, we can excuse the departmental officials from National Treasury. Oh, I spoke too quickly. Member Nkondlo.
No, apologies, Chair. Can I just maybe request National Treasury? I'm not sure whether the benchmark study has been concluded. Can I just request that if it is, if they can share as such with us? Thank you.
Yes, please. I think that's also something we can note in the negotiating mandate and request. Absolutely. All right. To our colleagues at National Treasury, we know that you have had a huge amount of work before you, having to take on so many submissions on a bill that is, I don't want to use the word contentious, but maybe that's the only word I can use. There's been a lot of input, there's been a lot of interest in it, and we know you've had your work cut out for you. So thank you for taking the time to talk us through all the comments today. Thank you for joining us in our various standing committee engagements with the public. You've really been an asset, and we've really, really enjoyed working with each and every single one of you. And we hope to keep this relationship alive and well. So with that, thank you again. And I hope that we can stay in touch and speak soon. You're welcome to pop off.
Thank you,
Thank you,
Chair.
Chair.
Thank you.
Chair.
Thank you.
Okay. Members, I would like to get an indication from you. I know we have been at this since 8 o'clock, so an hour and 45 minutes. Do you want a 15-minute break and then we can come back and dive straight into the negotiating mandate? Or would you like to continue? Member
Okay.
van der Westhuizen?
No, I think a brief break would be wonderful. And shall we then resume at 10?
Yes, that's perfect. We'll resume at 10. Okay. Thank you, members. See you shortly. The matrix of submissions can also be used as a reference. I think some things just off the top of my head and from the discussion that we had with PT that I would like to register are possibly the use of thresholds rather than targets, and that's something that we could add under definitions, for example. And I think, for example, 17(2)(a) was used. Then under prescribed number of tribunal members, this is something that the bill could also possibly introduce as a way to minimize the minister's powers or prevent overreach. Then, of course, on the SARS report, requesting a benchmark conducted of other national treasuries when it comes to procurement. But members, I'm opening up the floor now. I recognize Member van der Westhuizen.
Thank you, Chair. May I first just propose that we decide as a committee whether we want to oppose or support, or perhaps support with conditions, etc., all the various options available to us, that we do that as a point of departure in formulating our negotiating mandate, please.
Yes, please proceed.
Thank you, Chair. Chair, having listened to the department's responses, having considered the concerns and other inputs received, I would like to propose that we do not support the public procurement bill in its current format, and that we will, obviously, I will expand on why I believe that would be the most appropriate response from the Western Cape. Thank you.
Thank you very much. Members, if I can get an indication on whether to support or not support. Member Seleko?
Good morning, Chair. Thank you very much, Chair. I've been listening attentively and I've been following the inputs during our short yet time of inputs from the public, and I would concur with the proposal of Member Enriquez that we should not support this particular bill. I will elaborate at a particular stage. Thank you very much.
Thank you very much, Member Nkondlo.
I'm sure it has become obvious now, Chair, how we support or not support from party lines. I would move on my vote. What you call this Rule 90 to support the bill with conditions which, as and when the time is provided for, one would present those considerations, not conditions, those considerations. Thank you very much.
Thank you very much. So that's noted as a minority view. Then members, if we can move on to a discussion on what is it that you feel those substantive changes should be? What are your proposals so that we can help to formulate the draft of the negotiating mandate? Member Nkondlo, is that a legacy hand?
Yes, it is.
Okay. Member Seleko?
No, Chair, thank you very much. Chair, I'll start with the procedural concerns, and I've been consistent in this regard, Chair, and I have to state my unhappiness in terms of the time that we've been given by the NCOP, which is not even complying with their rules of order, which is Rule 293, that at least people must be given about 8 weeks to deal with legislation. And if one has to remember, when we were given this particular bill, it was less than 3 weeks. And, we need to keep on emphasizing, that we are not given enough time to deal with bills coming from the NCOP, because they just want to get through the bills, and without giving the Western Cape enough time for the public to comment on these bills that is going to have an impact on their lives. That is just my first comment pertaining to the procedural issues, Chair. Thank the time constraint. Thank you very much. I'll give over to Member Nkondlo to support me on that one.
Thank you very much. Members, if you can please raise your hand, indicate if there's anything that you would like to add to the negotiating mandate. I see Member van der Westhuizen and then Member Nkondlo.
Yes, thank you, Chair. And obviously, Honourable Seleko, having served in the NCOP, knows their regulations and internal affairs far better than myself. And so I can only support him in that in that this really was a highly rushed process. So please, if we could raise that. Then the second one is also, apart from the time concerns, Chair, there are also substantive concerns, such as the definitions. I think you've also referred to that, and it seems to me as if a prescribed target is, for example, one of those definitions, because for me there's an anomaly in aiming for something, but then simultaneously prescribing that as a minimum threshold, etc. So that is an important one for me. Also, Chair, is the minister's power is a concern, and you have referred to the fact that, for example, the minister will now be appointing members to the tribunal, but then the tribunal is not going to be as impartial, I fear, as it should be, because on the one hand, it's the minister that appoints the members to the tribunal. But on the other hand, as we've heard this morning, this tribunal is, for example, to be fair and is supposed to be hearing, the state versus small enterprises. But, the tribunal is part of the state. The tribunal members are being remunerated by the state. And I can just think that there is a tendency then for a minister to rather appoint tribunal members that would, can I call it, be in line with the policy, etc., of the government of the day, and not being as unbiased or neutral as I would like it to be. And it doesn't seem to me as if in our case, sometimes we meet and we interview members for tribunals, and we even eliminate people in terms of the fact that we believe they're not suitable. But I do not read anything like that in terms of this proposed bill. There are also various other substantive issues, Chair. For example, in clause 20, where sectors for local production, etc., and content is to be designated. I think the main thing that we try to achieve is to get greater, can I call it, efficiency in terms of public procurement. We need to enhance the competition among suppliers and not narrow down. On the one hand, we've got a competition commission that is working very hard to eliminate unfair competition. On the other hand, this bill opens up the door wide for supply chain management managers to narrow and exclude, for example, certain individuals and entities from taking meaningfully part in procurement processes of the state. And we've seen, for example, in the Cape Town port, when, for example, original manufacturers have been excluded, but they're the only ones that can really provide the, can I call it, spare parts, the individualized or the tailor-made spare parts for certain of those important cranes, etc. And what has happened? Eventually, those cranes have not been repaired in time. Exports have suffered. The economy of South Africa have suffered, etc. So I really believe that, unfortunately, this bill is in that regard not serving the best interest of South Africa. The whole issue of constitutionality has been raised as well. I do not fully agree with the interpretation that Section 217 in the Constitution of South Africa is that wide, and that it opens the door for what we currently have in front of us. And perhaps I must pause for a minute. I can continue for quite a while, but perhaps if members would like to discuss the points I've raised, let me just stop there first. Thank you.
Thank you very much. Member Nkondlo?
No, thank you, Chair. Chair, I think on the procedural and process matters, it would help colleagues of this legislature to actually lead by example. You know, it's very interesting to want something that when you are given an opportunity to walk that path, you actually work opposite. It's a very interesting way of leading. You criticize other people for things that when you have a chance to do, you are unable to do. I mean, really, the chair, the chair who was chairing a powers bill here, I mean, flouted the same processes now, wants to go on and on about a process of the NCOP, and I don't think we can take such from somebody who's unable to do it for themselves from a party point of view. I think the one issue for me, I fully support this bill. Support it because in the current, and I think it was exactly this parliament, including in many debates, where there was a discussion about, I think, the instability from the case on the procurement framework, which the courts had indicated that National Treasury, you know, within expeditiously actually must close the gap in creating a framework. Now the framework is here. And now, colleagues, as it is said, it is on public participation so that this framework gets to be enriched, and therefore there is policy certainty for the public procurement. And public procurement, we underscore public, because it is procurement in the interest of the public, not in the interest only of the markets that are participating, but also of the state that is procuring these goods and services. Like any corporate interest, as and when they procure goods, would actually determine what are its interests in terms of value for money. So I think from where I'm sitting, the support of this public procurement bill is actually something that is very crucial to do in taking further the intention of our own constitution. Section 217 that member Andrika says does not believe that it is that wide. I think if it is in the interpretation, surely would leave it at that. But I think the case referred to by constitutional judges have explained what Section 217 states, because it is in that constitution, both in its preamble and its Bill of Rights, that socio-economic rights in South Africa are part of rights, as we talked during a human rights, are part of rights of all individuals. But it also takes into cognizance a peculiarity of this particular country, a peculiarity of others who would have benefited unduly and unfairly from a previous system, which actually that system is embedded, because that system was never a system that actually could have been collapsed in 1990, 1994. It is embedded, and that is why correctly the reference made of Competition Commission, of the structural issues that Competition Commission is trying to do, and this bill is actually going to be able to enable and strengthen even further the state obligation, because here we're talking about the obligation of the state to implement what the Constitution states. So that if colleagues are not happy with the Constitution and its provisions, they must take the Constitution to court and get the Constitution, or go to the polls and get the Constitution amended. But the reality of the matter is that we can't delay the procurement framework, because this is what this is. It is a framework for public procurement to enable the state to correct the public the problem statement that has been identified, which include the structural problems, which year in and year out there is ample studies that actually demonstrate why South African economy is not competitive. It is because of some of its structural problems. And indeed, even in the bill, the categories of procurement in the various sectors of procurement, it doesn't mean that this bill now is actually silencing those. There are individual categories that would then explain the peculiarity of those particular categories, but also to take note that South Africa needs to balance its industrialization interest, because when we do not take that into cognizance, because others are comfortable with the fact that South African economy will always have to depend, on the international markets, which those international markets are linked to only a few that have, some are beneficiaries of the old system and not opening up to its own industrial capabilities, which localization and local content is about, is to create capabilities within the country so that other countries, like the countries we are celebrating today of China and others, they had to make the decisions about their own domestic interest. We can't, as an economy, always, because it's the same economy that colleagues would then, criticize about it unable to deliver to its own public interest. So indeed, public procurement is a very critical tool. You can actually go and look, even in the case in the United States, the most developed economy, they use public procurement to deliver what the United States or American interests are about. So I believe, Chair, that amongst others, there should be more clarity on definition, so that this issue of set-asides, I think, which I think becomes a sore point for colleagues, to have set-asides, which are actually constitutional and is the right thing to do in the current context in South Africa, because we know, and we can see it here in the Western Cape, the competition between a new entrant into some of these so-called sophisticated industries is actually like trying to climb Kilimanjaro in terms of those who tries to get in now, even in the energy space. So definitions that clarify set-asides are important. And as we do that, we need to actually try and move into the space of considering these responses and some of the inputs that the procurement practitioners have actually made to enrich the bill, because the issue that we need to do is to enrich this bill and ensure that in the regulations that in any way are going to come back for public participation once again, that if there are issues that are more of operational nature, such be resolved there. So I just want to say, Chair, I support the bill as a bill that is much more needed in South Africa to stabilize public procurement and supply chain practices in the public procurement. And indeed, policy stability and policy certainty is what is required by those that are in the market and any other to ensure that there is certainty. So we can't delay this bill any further. Thank you very much.
Thank you very much, Member Nkondlo. I think before I hand over to Member van der Westhuizen, I would agree and also recognize that clauses, for example, relating to beneficiation are very progressive. I think it's definitely a move in the right direction in terms of ensuring that we really do get value for money when it comes to improving the value of our raw materials before we export them. And that would really enrich our country. Having said that, I do think that the bill itself does need a lot of work. For example, we've discussed issues around constitutionality, over-reliance on regulations, judicial review, ministerial overreach. But let me hand over to Member van der Westhuizen.
Yes, thank you, Chair. Chair, I think there are certain points in which we all agree, but I think there are others in which we will have to agree that we will disagree. For example, when it comes to the constitutional principles, if I can quote from the response that we've received today, where they say the principles of Section 2171 are addressed in the objects to the bill and in the preamble to the bill. They say these are referred to. Now, to refer to the principles and to live or then legislate in line with those principles are two completely different things, and it's a pity that they refer to the preamble and the objects of the bill, and not address the real clauses in the legislation that are currently in front of us and that we are considering. So that is a serious concern for me. And I just think, I've now mentioned the situation in the ports. I can mention the situation at Eskom. You know, our public procurement up to now have unfortunately pushed up the prices of electricity far higher than what our inflation rate has been, which has impoverished most South Africans that rely on electricity for their energy needs. So, and I do not see in this public procurement document that, you know, for example, in future, that the price of electricity will come down because of greater competition in the market for procurement of services and goods for, say, for example, a state entity like Eskom. So, and we have other state entities that are also unfortunately bound by public procurement regulations, and unfortunately, we've seen with almost all of them that they have priced themselves completely out of the market, and eventually the broader interests of South Africans have not been served. As a matter of fact, cost of living has become an extreme problem. Unemployment has become an extreme problem, etc. At one stage, we were highly competitive in terms of, say, for example, electricity prices internationally, and we've lost that competitive advantage which our manufacturers and industries enjoyed. So, but I think we must unfortunately agree that on that one we've got different views, and that we will not meet one another, and that I would like us to emphasize in our responses, as I've said, that we should not look at the advantages that this may bring for some individuals, but then must really look also at the disadvantages for South Africans, broadly speaking, when we should try and abuse public procurement for certain very sector-specific gains. So, Chair, I hear what the Honourable Kondo is saying. Some of what he's saying is extremely is true, such as that this public procurement is extremely important. But I do not believe that what this in the preamble and in the object set out to achieve is eventually what we will see should this be adopted and become an act of parliament. Thank you.
Thank you very much. First hand I see is of Advocate Kole, then Member Seleko, then Member Nkontlo.
Thanks, Chair. What I wanted to highlight was on the issue of public involvement as a constitutional entitlement. Chair, for me, what was notable or what was glaring in the submissions that we received is that the intended beneficiaries of, for example, the pre-qualification provisions, their submissions, they are very few and far between. And that I put at the door or lay at the door of that the public participation process, the time frames were too short. So, you know, Chair, if, for example, this bill is waiting, and ideally you would want to have some legal person looking over the bill. And if, for example, you're living purchase order to purchase order, firstly, you will have to get the resources, and then council will need at least a week to properly consider the bill. So my view is that the timeframes were short. So when we did receive submissions, they were from a few number of businesses within that category, and then the quality of those submissions, like for example, one, it was about a totally different topic altogether. So we need to highlight the failure of providing a reasonable opportunity to the public to participate. And then on the second issue I wanted to raise, and which they don't properly addressed. They say, and are pains to mention that the provision on the searching and entering premises, it is compliance provision. But Chair, even though they use compliance, if you were to look at the provision and how it manifests itself, it actually is more akin to criminal searches. So I just think that even though they use the word compliance, it's not actually in compliance. And the one provision or the one act that they use to say that it is the same as is the Property Practitioners Act. And in terms of this act, it says an inspector may at any reasonable time and without prior notice conduct an inspection to determine whether the provisions of this act are being or have been complied with. But, you know, when we look at the act or the provisions of the act, it is more in line with, or it compares more with the Criminal Procedure Act. So those are my, comments in that regard. Thanks, Chair.
Thank you very much. I recognize Member Seleko.
Yeah, Chair, thank you very much. I'll be very short, but I think, Chair, it's very unfair that when I'm in this committee that I'm regarded as a chair of the Powers Bill. I'm not the chairperson of the Provincial Power Bill. I'm a member of the committee, and my views must be regarded in that instance, Chair. Thank you very much. Chair, let's talk about I was part of the public hearings, and one would also want to remind and say there was an outcry, especially from the most disadvantaged communities or up and coming businesses when they were talking about funding, Chair. I think one should actually think maybe the bill should talk about how does the bill assist, up and coming suppliers, and how does the bill also try to guarantee that local, suppliers are included. And maybe, Chair, also the fact that we must also ensure that the bill makes economic objectives and its broad function scope that risk compliance procurement landscape. What we are trying to say, Chair, from the side of local government, we find it very difficult for up and coming businesses to be part of the economy, Chair. And because because legislation is making it actually more and more difficult for up and coming businesses to be part of the mainstream economy. And I think that's what we've been hearing everywhere we go. And I think the bill should be able also to try to speak to that. And also, Chair, I'm also a little bit worried about, where some of the powers from the province and municipalities will be subjected to one sphere. I think all spheres must be able to do their own procurement processes, and they must be able also to fulfill their own role. I think there shouldn't be one sphere, be superior than other spheres, Chair. I think those are just my input in this regard, Chair. Thank you very much.
Thank you very much, Member. I recognize Member Member Nkondlo.
Chair, I'm assuming that the second round that you have taken is to still continue to enrich the inputs of members and also the department that is still with us on the mandate. Safe to say, I'm sure Advocate Mpho.
Apologies, Member. So the department has been excused. Our discussion now is really about how are we going to enrich the negotiating mandate. So we've already voted. So now what are the areas that you want to change, add, so that we can ask them to improve it and give us the very best document. Thank you.
I was saying, Chair, I'm sure if we were to consider what Advocate Mpho speaks about, we'll have to go back to all our the quality of our public procurement, because that has been the nature of the issues raised about public procurement and the number of people that are there and how those people are relevant to the bill, and whether that can be resolved by the procurement bill or it's something that must be resolved by this legislature about public procurement and how we undertake public procurement to prepare people who make inputs. I think further, Chair, I think on the issue of the the measures, one I think that has been raised by the bill around those that do not necessarily advance or realize the contracting obligations. I think one would like to put also as part of the considerations in my support that the issues that are raised of considering other related legislations must actually be undertaken by National Treasury as part of strengthening the procurement, the public procurement ecosystem, so that indeed the likes of CIDB gets to be reviewed in consideration of some of the conflicting intentions of the bill versus what the individual, and it's not even only about CIDB, it's also in the other various categories, especially now we're talking energy, you know, which is also a new area. We had to deal, I think, last year with also a bill around, you know, the issue of renewables. And I think it will be important for this bill to consider, I think, going back in looking at alignment of those legislations, because one challenge that has always been out there is the fact that the different pieces of legislation, this one being a framework, must be in harmony with the related or other bills that actually seek to sort of be aligned to this main framework. So I think that for me is very important, especially on ensuring that the state does not lose much money, because what we consider the issue of price and others, we also must consider how some of the businesses have actually been able to get the state to lose money and its own time by not being able to realize the necessary contractual obligations, because once again, there is more of a concentration, particularly in most of these industries. You go to retail, you go to construction, you go to property, there's always a concentration, you know, right there at the top of a few corporates that are in there with the necessary sophistication, technology, and everything. And indeed, we need to broaden participation, as Member Seluku speaks about. SMMEs are unable to participate. They are not going to be able to participate if the state, because it's not in the interest of private markets to do exactly that. The states in all developing economies have had to intervene to enable participation of those that are in the periphery so that they can also be given an opportunity to participate. So it's important that that alignment, I think, for me, Chair, is very important, that we must actually call for it to be done by through this process, and it must be done actually as soon as it can. But also, I think the last one for me is that I think it's important to also consider how this framework is going to be aligned to our industrialization and localization policy. And that becomes very important in trying to ensure that, once again, that industrial capability of South Africa's economy, you know, is strengthened by this particular framework, so that you lessen actually the issue of red taping of the different legislations in this regard. So I think one of the issues for me that is important is the alignment of the industrialization policy and localization policy to the framework itself. And if it is possible for actually to put a time frame, whilst the colleagues have indicated that no, this will be done in phases, I think the sooner I think we're able to actually have a clear horizon on how and by when will this whole process be sort of getting to a stage where you've got a firm up procurement framework in South Africa to ensure stability and to give a policy certainty to both the domestic and international markets, including SMMEs that would really benefit, to participate in the public procurement as a way for them to, to build their potential and capability to participate in the markets. Thank you very much.
Thank you very much for the succinct inputs. Members, are there any further comments, anything else you would like to add that hasn't been touched on yet? Member van der Westhuizen?
Yes, thank you. Thank you, Chair. Chair, there are a number of other issues as well, apart from the procedural and the ones mentioned up to now. For example, the autonomy of provinces in dealing with procurement, I think, is being compromised by this proposed legislation. And then also, Chair, there are various concerns that I have in terms of the overextension into what I would call non-procurement areas, such as asset management and so on. The same also apply to overextending to local authorities' ability to, act in their best interest. Then also, I believe the bill should be defining the role of OCTA and particularly on the subject of local government, the role of SALGA. We do have a position on what we call cooperative governance, but I believe here we've got very much a top-down approach and not a cooperative one. I believe there are, a real risk of this bill contradicting or clashing with other existing laws, such as the BBBEE legislation that we already have. And then also, Chair, I believe that we should actually ask for can I call it a redrafting of certain sections of this bill, and that there must be a review mechanism where provincial and local governments that find that there's now an infringement on their field or their legislative competencies, that they, for example, would be able to take some of this on review and have the freedom, as I've said, to act in the interest of their mandates that they need to fulfill, etc. So that's why I honestly believe, Chair, that this is the concerns are just so many that I believe it would be very difficult for the NCOP to really resolve all of those concerns before the end of this Parliament. And Chair, I would like to predict that what we're going to see is the NCOP perhaps rubber stamping this bill, but I would like to state clearly that I believe that the Western Cape should not be part of such what I actually would call a dereliction of duty by the NCOP, and I certainly do hope that they will be proving me wrong. But those aspects that I've listed, Chair, I would love them to also be incorporated into our negotiating mandate from the Western Cape side to the NCOP. Thank you.
Thank you very much, Member van der Westhuizen. Members, I'm just checking one last time if there's anything else you'd like to be added to the negotiating mandate. And if not, we will break and allow Ms. Adams to pull together the negotiating mandate. Okay, With that, members, Ms. Adams, if you can just indicate how much time you'll need.
Thank you, Chair. Can you give me about 30 minutes so far, and I'll see how far I get.
Okay, members, we'll check in again at 11:10. Thank you.
Thank you, Chair.
Okay, Member van der Westhuizen, sorry, I saw your hand.
Just a thank you. See you then 10 past.
Thank you. Bye. put it together. I also want to thank members for their comments and for having sent through more meatier explanations of their high-level comments on the bill, which we'll see reflected shortly. If I could ask Ms. Adams to pull up the negotiating mandate draft so long. In the meantime, members, what we're going to do is, it's quite a lengthy negotiating mandate, so we'll just scroll through it. And if members see anything that they want to read or just stop, reflect on, talk about, or amend, please just interject, and then we can have a look at that. But there are approximately 10 pages in total. Okay, we'll scroll up, and perhaps we can just put it on an A4 setting, so it's just a bit bigger. There we go. Okay, members, I'm going to scroll through it now. Please shout. You don't need to raise your hands. You can just unmute and interject if there's anything you'd like to comment on with regards to this negotiating mandate. Yep, we can scroll down. Okay. We have the Standing Rule 90 for Member Nkondlo with some of the considerations. Okay, members, that is the draft negotiating mandate. Please indicate whether you're happy with the report or not. But if before that you also have any changes you want to make, you're also welcome to do so. Can we adopt? Member Seleko?
Chair, I'm more than happy with the report, and I so propose. Thank you.
Thank you very much. We get a second, Member van der Westhuizen.
Thank you. I will second that proposal.
Hey, thank you very much, members, for all the hard work on this. We are nearly there. So the next matter that we're going to be dealing with is the deliberations on the final mandate for the Upstream Petroleum Resources Development Bill. The members will note that there were documents or minutes received from the NCOP Select Committee that speak to the negotiating mandate submitted by provinces to the NCOP. So members, let me just quickly call on Ms. Adams. Ms. Adams, I'm not sure if there's a particular document that we can just pull up for the record for members. Perhaps the comments from NCOP for the Western Cape. Okay, so we can just scroll through that. And just to refresh members' minds, we we did not support but had a minority view, and that was subject to several amendments. Okay, is that the end? No, still page 5. Okay. All right, members. I see Member van der Westhuizen has already raised his hand, but yes, if I could please get an indication of how you wish to proceed, including whether to support or not to support. Member van der Westhuizen.
Thank you, Chair. What I see is that none of the proposed amendments by any of the provinces were acceded to by the Select Committee. And that, I believe, leaves us with no other position but to continue our position to this bill in its current format. Thank you.
Thank you very much. I support that as well. Any other members who would like to comment?
Chair.
If you don't mind, Member Nkondlo first, then Member Seleko.
Okay, Chair.
Please register our minority view and to support the bill.
Okay. Member Seleko?
So, Chair, I just wanted to check, didn't we provide the NCOP with some proposals during our negotiating mandate?
Yes.
Because it's with interest that some provinces, there's comments that none of the amendments were proposed, been taken into consideration, but when it comes to the Western Cape, there's no mention whatsoever, as if we did not even propose anything. So based on that, I would wholeheartedly stick to our negotiating mandate not to support this particular bill. Thank you very much, Chair.
Thank you very much. Member van der Westhuizen, I recognize you.
Yes, thank you, Chair. And I would love our minutes to reflect that the NCOP did not consider any of the proposed amendments favorably. And secondly, that it seems as if they didn't even note the Western Cape's proposed amendments to the bill. Thank you.
Thank you. Yes, complete waste of our time if that's the case. Member Seleko, I saw your hand briefly go up. Was there something else you wanted to?
The right, Chair. Thank you very much.
Okay. All right. With that, Ms. Adams will just need a little bit of time to draft the report, which we can read into thereafter. Ms. Adams, how much time will you need just to draft that report, and then we can reconvene?
3 minutes.
3 minutes. Okay. No problem. We can hang around, and when you're ready, you can just indicate, and then we can resume and read that in. All right, members. Ms. Adams has completed drafting the report for the final mandate. If you could please pull that up, Ms. Adams. Okay, perfect. Members, I'm going to read this into the record. Committee report, final mandate stage, draft report on the Standing Committee on Finance, Economic Opportunities and Tourism on the Upstream Petroleum Resource Development Bill, B13B 2021 NCOP, dated 22 March 2024. The Standing Committee on Finance, Economic Opportunities and Tourism, having considered the subject of the Upstream Petroleum Resources Development Bill, B13B 2021 NCOP, referred to it in accordance with Standing Rule 217, recommends that the House confers on the Western Cape delegation in the National Council of Provinces the authority not to support the bill. If there is a minority view, there is a minority view. There we go, perfect. In accordance with Standing Rule 90, the African National Congress expressed its minority view to support the bill. Okay, members?
Chair, Member Brankes here. I would also like Al Jamal's minority view to be included in the mandate, also to support the view. Thank you.
Okay, cool. Seems Adams is just adding it there. Perfect. Members, are there any other amendments? If not, can we get a proposer?
Propose, Chair.
Thank you. Seconder, Member van der Westhuizen.
Yes, Chair, I will second that. May I just ask that in the first sentence, that the space after this 22nd of March be deleted and replaced by control shift space. That is a non-breaking space which will allow the 22 to appear in front of March in the next line. It might not, with track changes, do it immediately, but after 22, the two positions to the right, yes, control shift space, and then delete the existing space. Thank you.
Okay, thank you very much. So there you have it, members. We have adopted our negotiating mandate today, and we have done our final mandate. We've been very, very productive. So thank you everybody for that. I just want to move on to any resolutions or actions emanating from today before we close off. Okay, I see no hands. I think the only resolution really from my part is just the requesting of the benchmarking information, which Member Nkondlo raised from National Treasury. Member van der Westhuizen?
Okay, this may be under the next point on the agenda, general, but I would like us to also, as a committee, express our gratitude towards Ms. Adams and the other support staff that have been under tremendous pressure over these last few weeks to finish with very, very tight timelines, and that we acknowledge, you know, these tight timelines as well as the hard work by those officials. I think it's just for us to give credit regarding that. And then lastly, a question, Chair, is there any other meetings envisaged in the foreseeable future for this committee? If so, if we could just be informed of that. Thank you.
Yes, thank you very much. I agree. First of all, we couldn't do any of this without the supporting staff, and particularly without the adept hand and mind of Ms. Adams. So thank you very much all. We really, really do appreciate all of the insight and support. We couldn't do it without you. In terms of meetings, so yes, we'll still need to do the final mandate for procurement. And am I missing another one?
National Enterprise.
National Enterprise, yes, sorry. We'll still need to do those two. Ms. Adams, if you could just remind me, when are the dates for those?
Thank you, Chair. So I don't have dates exactly, but I'm looking at the 12th of April because the final mandate on the public procurement is due by the 17th, and the small enterprise final mandate is due by the 16th.
Thank you very much. Member Nkondlo?
No, thank you, Chair. Chair, I wanted to check with yourself and the committee. I have received a request from two members of the public representing a different organization on some matters that they would like to present to the committee. Could you advise of what process should those members follow?
Okay. Is it possible to get more information about what they wanted to speak about? Or if you could, I'm not sure if it's in an email correspondence, then I can just chat with Ms. Adams offline and we can apply our mind on how best to engage.
Can you hear me, Chair?
Yes.
Okay, thank you very much. We'll definitely forward you that information because I had requested them that they would need to send the emails to you and copy Ms. Adams for the request of those presentations to the committee.
Okay, perfect. Thank you so much. I really appreciate that. Okay, members, I hope you have a wonderful weekend, very restful one. And I look forward to engaging with you soon. All right, have a great one, everyone. Thank you for all the hard work. Really appreciate it.
Thank you, Chair.
Thank you, Chair.
Thank you,
Thank you,
everybody.
colleagues. Thank you, Chair. Bye-bye.
Thank you.
Thank you,
Bye.
Chair.